Good afternoon. Welcome to this special occasion, International Anti-Corruption Day. It is apparently, which is the day when all corruption internationally has to stop, but it gives us an opportunity, and I've been invited to take the opportunity with Robert Redlich, the Commissioner for the Independent Broad-Based Anti-Corruption Commission, to speak publicly, frankly and fully in a completely unrehearsed and open slather interview with me. I'm John Fain, and welcome. It's an absolute privilege to have been invited to conduct this interview. And first we'll acknowledge that we're on the lands of the Wurundjeri Wurrung Bunurong people of the Kulin Nation. We pay our respects to their elders past, present and emerging. And also I pay my respects not just to those people, but also express my personal impatience for a treaty or treaties in order to repair some of the damage of our past. Commissioner, thank you for inviting me to have this conversation with you as you prepare to leave this important office. And we should establish some of the ground rules first. I've been given a briefing, but I haven't been told what I should or shouldn't ask. So why have you decided to take this opportunity to speak publicly and frankly?
Well, I think I've come to realise over time that it's important for the Commissioner of an organisation such as this to speak publicly, because there are so many messages that otherwise don't find their way into the public domain. It's been a combination of circumstances. I've had to overcome the diffidence which comes with a former judicial life where the only way judges spoke was through their judgments, but come to realise that there are really important messages that need to be conveyed to the community.
Does it go further than that? Are there misperceptions, misunderstandings, mischaracterisations of the work that you and your organisation has done because of that reticence to speak publicly?
Well, there probably are, but that's not driven me to feel I should speak publicly, because with the effluxion of time and the publication of reports, I think some of those misconceptions would get dispelled. It's really the opportunity to convey some powerful messages that has driven me to speak.
There can be damage done, though, from that reluctance to speak. I'm sure there are days where you can pick up the newspaper or see something on the television news or hear on the radio something that you know is wrong, but you can't do anything about it.
No, the organisation, as it should be, has a very prescriptive regime under which it works, so that we're precluded from saying things about investigations until they become public. There's lots of misconceptions, people sometimes speaking with agendas.
Sometimes? Always?
Well, perhaps often, but I think the important thing is that there's confidence that when eventually the organisation is able to publish findings or present its position, those concerns can be dispelled. It is true to say, however, that the privacy of so much of what we do does give rise to misunderstanding, misconceptions, conspiracy theories.
Damage to individuals.
Yes.
Don't you? I mean, it's a difficult balance, but don't you have an obligation to try and minimise that damage and those conspiracy theories, which in recent years we've seen have been so corrosive of democracy?
Only to the extent that the Act enables us to do that. The Act, as I say, is very prescriptive, so that nothing that concerns the detail of any matter under investigation can be revealed until such time as a report is published.
We are operating under some difficulties because we can't breach the Act that you work under, but there are questions I would like to ask, and whether you can answer them, I don't know. So I'm going to ask questions.
Yes.
And if you aren't able to answer them, there are some where I'll press you and others I'll just have to give up. How many investigations are underway at the moment?
About 35.
How many of those relate to what we would call serious corruption as opposed to what is often referred to as grey or soft corruption?
Most of them.
How corrupt is Victoria?
From my perception, no more so than other states around Australia, but we do have serious corruption issues that need to be addressed, and no doubt we'll speak further about those. I'm particularly focused on what I call soft corruption. That is corruption that doesn't necessarily involve the commission of crimes, but which is quite deleterious to good governance and ensuring that the outcomes of decision making serve the public interest.
So of those 35, how many would involve crimes, do you think, even if they're still not complete?
Well, our jurisdiction's enlivened by a suspicion that conduct might constitute a relevant offence. Very often, on further investigation, it becomes apparent that it isn't a crime that's been committed, but soft corruption, that is non-compliance with processes, breaches of standards and conventions, which from my perspective is equally serious and has the same consequences as hard corruption.
How many of those 35 involve politicians?
I don't want to descend to a level of particularity about any of the individual investigations.
Some of which are already public, though.
Well, that's true. If you were to ask me about anywhere there's been considerable conversation already in the public domain, I might be prepared to confirm that some matters are or have been under investigation, which we've not previously acknowledged to be so, because I think that if there's enough information out there in the public domain, I see little point in continuing to fail to respond.
Well, there are, let's go through the ones that we do know about, and then there are those about which there are rumours.
Yes.
Whether you want to dispel or confirm the rumours or just say no comment is entirely up to you. So we know there's Operation Watts.
Well, that was a public hearing, and we've tabled a report, and we made some. This is the investigation that we did in conjunction with the Ombudsman. We made very important recommendations, and I was pleased to see that without hesitation, the government has said that it will adopt all of those recommendations, which would result in powerful reforms being made within Parliament in relation to integrity.
And that was in relation to branch stacking and irregularities within, in particular, the Labor Party. And one of the key people in that was Adam Somyurek, who may even be re-elected to the Parliament, despite your report and its findings. What do you make of that?
It's a matter for the electorate, John. Politicians have a difficult road to follow.
I haven't got a violin small enough.
I think it's important to understand that frequently when we're talking about soft corruption, which is what we were dealing with in Operation Watts, people don't really have an adequate insight as to the fact that they're behaving in an unethical way, that they're simply following a culture which has been endemic for a long period of time. So it's rarely the case when we're speaking about politicians, it's rarely the case that we've encountered willful, conscious, dishonest conduct that involves serious crime.
Eddie Obeid scale in New South Wales, for instance. Yeah. So that's not what most of these are about.
Correct.
To clarify. So even though the headline figure 35 current inquiries will raise eyebrows everywhere, important to point out that doesn't mean that there's a whole lot of people scurrying around with paper bags full of cash at the moment.
Correct.
Yeah. Okay.
Very few of them involve that sort of issue.
Disappointingly few?
No. As I say, I think it's much more important that we focus on soft corruption.
Yeah. It's much more common is what you're telling us.
And more serious.
Okay, so then we go to the Sandon inquiry, which has also had public hearings, which has been universally described as the Ferrari driving property developer, Mr Woodman. That is stalled by litigation by participants in that inquiry in the Supreme Court, as I understand it.
That's true.
Is there any light at the end of that tunnel?
Very close to the end. The litigation in that matter was on a narrow issue, and I think in the next few days that litigation will come to an end.
Days?
Yes, and then we will be able to proceed, hopefully, in the very near future with the publication of the report and a huge raft of recommendations, some of which have already been addressed in the context of the lobbying and donation report that's been tabled, but really important reforms that need to be grappled with.
Reforms to do with the operation of political office with the portfolio that is being administered. So
a small portion of that, it relates to that. Much of it relates to planning. Much of it relates to the way in which local government operates.
The litigation was about a fine point of law to do with effectively natural justice, people having an opportunity to test evidence, see evidence and so on. Is it your hope that having the decision of the court to be handed down, as you tell us now, in days, and assuming it goes well for the IBAC then, and you can release your report, that never gets tested again? That puts to rest the delays that have arisen in other matters as well, which we'll come to in a moment, in finishing some of your work.
I'd like to say that it will put those matters to rest, but you, John, would be very familiar with the ingenuity of lawyers in terms of finding legal arguments. People have rights which they're entitled to exercise, and I don't think the Woodman litigation would see an end to legal arguments about parts of the natural justice process when we are trying to convey to people, persons of interest, what is the extent of the evidence against them and give them an opportunity to comment. One can readily see opportunities for further litigation.
Which brings us to Daintree, just somewhat inconveniently on the cusp of a state election. You found yourself going to court to stop the release of a draft report in what's called Operation Daintree, which is to do with an investigation into an arrangement entered into between the state government and the Health Services Union. There's some suggestion, first of all, we can confirm that that operation exists, it's public, It's not a secret at all. Secondly, the litigation was to stop the release of information from a draft report. Why did you go to court?
As the Act provides, when we conclude the investigation and seek to table a report, we must prepare a draft, and that draft has got to be provided to every person who is mentioned in the draft. And you'll appreciate, particularly in an investigation that's been totally private, the first time that some people mentioned in the report will see the extent of the material against them is when they read that draft report. They have to have a fair opportunity to respond to the preliminary views that are expressed in the report.
So it's not only the people who are suspects in inverted commas, but all the witnesses also.
Correct.
It could be a huge number of people who didn't know that other people were witnesses and suspects.
Correct. And the Act provides that in providing the draft preliminary report to people, it is an offence for each person who receives that draft to disclose it to other people.
Other than their lawyers, I think.
Other than their legal representatives, correct. Our difficulty with the government over the form of the legislation is that whilst it makes it an offence for the individual who receives the report to disclose it, it doesn't prohibit the media from publishing that confidential information if a person has unlawfully disclosed it to the media. Now, I noticed that the Premier in his debate with Mr. Guy used some colourful language in saying that our object is to try and lock up journalists.
As in
that is IBAC's. Of course, that's not our objective any more than we would suggest that legislating to make it an offence for the individual to disclose the content is to want to lock up the individual. But once you have a law which says it's unlawful to disclose that material, our representations to the government, which regrettably fell on deaf ears, was you need to prohibit the media from also publishing that material. Absent that prohibition, we were faced with the dilemma that plainly the government's expectation and Parliament's expectation is that we would take whatever steps were necessary to protect the confidentiality of that information.
Sure.
And so we run off to court in civil process, seeking an equitable injunction to restrain the relevant media outlet from publishing. Now that's not an ideal solution.
And it didn't work anyway because another media organisation then published much of the material you were trying to stop getting into the public domain.
The solution is not for the Commission to have to run to court to get an injunction in every case. What I'm hoping is that we can persuade the government that they should enact a provision similar to the New South Wales ICAC, which permits the Commission in cases of sufficient seriousness and concern to make an order prohibiting the publication
by anyone of anything. There's a suggestion, and it's been alleged, I don't know on what basis, that IBAC cooperated with the Premier's office to stop the distribution on the cusp of a state election of a draft report that would have been embarrassing to the government. Did IBAC go to court after the government asked it to?
I'd rather not comment on that, John, except to say there plainly is a government expectation that IBAC will protect its confidential information.
So once you learned, however it happened, once you learned that there was a publication pending, were you following anyone else's requests or directions to take out an injunction?
No one directed us. We made an internal decision that we really had no choice but to protect the confidential information because these were only our preliminary views and we had not yet received the responses from all individuals and they had not yet had an opportunity to clarify whether there were things in the preliminary views expressed that were wrong.
So how did you feel after you took an injunction against The Age? And I think I can join the dots, and once you learned, and however you learned, maybe it was from the Premier's office or someone else in politics, this is circulating. You went to stop The Age publishing it, and then the Herald Sun pretty much went and did it anyway. How did that make you feel?
I'm not sure that I had any particular feelings about it, John.
It would be natural to be frustrated.
We did what we could. This is a dilemma, though, that the government has known about for a considerable period of time. As I say, our representations that there needed to be some additional legislation to enable the process to be dealt with appropriately has not been forthcoming.
All right, we'll come back to relations between IBAC and the government, but there's another inquiry that is widely believed to be underway, and it's never been confirmed or denied. Is there an investigation into the Firefighters Union?
There was.
Was past tense?
Was. The investigation concluded probably 18 months ago.
And what's happened to it?
There's a draft that's being prepared and we wait whilst litigation takes place.
Is that what's called Operation Richmond?
Correct.
Is that because it's got something to do with the suburb Richmond?
No. Our practice has been to name investigations after rivers in Victoria.
I won't ask why. It's like cyclones and tornadoes, I suppose.
Indeed.
So why has that draft report not been made public?
Because there's litigation on a number of fronts, which I can't tell you that, I'm sorry. So people understand, the IBAC Act is very prescriptive that an investigation whilst an investigation is ongoing or has been concluded but not yet been the subject of a published report, no one within IBAC is permitted to talk about any of the detail concerning that investigation, and it would be an offence to do so.
So we can confirm that it exists.
Yes.
We can confirm it's concluded. We can confirm there's a draft report. We can
there's a draft report being prepared.
And it's frozen by litigation by an unknown party, but in the Victorian Supreme Court.
Yes.
Would that litigation be influenced by the decisions in the Sandon inquiry into Woodman? In other words, would that decision would it influence or be a precedent for the other one, for the Richmond inquiry?
Well, we haven't progressed as far in Operation Richmond as we have in Operation Sandon. We haven't yet reached the point of disseminating the preliminary draft in Operation Richmond to the persons of interest and others mentioned in the report.
Because of the court action?
Correct. But it might well be, and I fear likely, that there will be litigation of a similar nature to the Woodman litigation in relation to that matter. So it could still be a very long time before it sees the light of day.
There's a certain irony. You used to be a Supreme Court judge, and yet it's now Supreme Court judges and the process, the snail's pace process of some of this litigation that is frustrating the work you're now doing as the IBAC Commissioner. How do you fix this?
It is frustrating, and I think part of the solution would lie in there being a judge or judges allocated in the Supreme Court who will give priority to litigation that involves the public interest.
An IBAC list.
Well, not just IBAC's not the only party who'd be pursuing public interest matters.
You'd hate to think there'd be so much litigation that it kept a judge occupied.
No, but right now there probably is, as we speak. But part of the difficulty is that judges, of course, have got a large list that they're responsible for. Sometimes the litigation can be very complex. In other cases, not so. But we just have to take our place as litigants.
Yet there's a prevailing public interest in the work that you do.
Of course.
Far more so than normal civil litigation between commercial parties. So there'd be an argument for saying too, is it the Chief Justice who would decide to allocate someone for a priority stream or a list?
Well, most cases go into the list to which the subject matter belongs. Chief Justice can give priority to something. I really don't want to descend into an analysis of how the court has managed the number of cases that regrettably have gone there. But I think it's important from a legislative perspective that we have legislation that might encourage the expedition of the litigation.
Is some of this just teething troubles for IBAC?
I would like to say it was. I fear that it is simply something that we have to continue to live with.
Do you think people are abusing the law in order to try and extract advantage by causing delay?
In some cases.
So litigation achieves delay, delay achieves through the back door what you perhaps are not going to achieve through the front door.
In some cases.
Putting off the inevitable.
In some cases.
Including prison? Or criminal prosecutions rather than prison?
I would rather not express any view
criminal
about
prosecution?
That. In some cases.
Okay. IBAC was used as a political weapon during the election campaign too. Both sides of the parties that can form government kicked the IBAC football around. What's your response to that?
That's an occupational hazard for an integrity agency. I mean, we start with the not uncommon practice that when a politician makes a complaint to IBAC, it's followed instantaneously with a public statement that I've complained to IBAC about such and such. So it's a political football from the very outset. That's just an occupational hazard for an integrity agency who was looking at the way in which executive government operates.
Is it partly, though, going back, this is now coming full circle to where we were before, your reluctance to triage, so to speak, the complaints to you, means that it opens up the possibility to create doubt in the minds of the voters by saying, I've referred this to IBAC, which comes with a whole package of suspicion, and the slur of I've referred it to IBAC can be used to advantage. Whereas if IBAC was more open and said, yeah, in 24 hours we've had a look at that, it's nonsense, go away, that would put an end to it, wouldn't it?
Yes, if we had reached that conclusion. That's an easy solution in circumstances where immediately on its face the decision is made that our jurisdiction isn't enlivened. But in most cases it's not as simple as looking and immediately being able to resolve the complaint. Particularly when they come from politicians, there will be some semblance of genuineness about what's being said, and that will take some time to examine.
It's almost like you, I mean, I said triage before, but it's like you sort of need some way of saying, yeah, come on, we'll look at it, but there's not much to it. Or it's a bit like committal to trial in a criminal prosecution. You can say, well, is this going to stand up to the even most basic scrutiny for us to even devote resources to it? Is that worth exploring?
I think anything which can expedite the process. As I say, if it's apparent that a matter does not give rise to a reasonable suspicion of corrupt conduct, it can be dispensed with very quickly. But IBAC has never seen itself as having the immediate function of making public announcements about the fate of complaints that are made. We would much prefer to see a provision, and we've asked the government to consider it, that people that make complaints to IBAC should not be permitted to make an announcement of the fact that they have complained to IBAC. I don't think that's going to be embraced, that proposal, but as I say, it's a harsh but a political reality that people will misuse an integrity commission for the purpose of political gain.
Going back to our listing, we've confirmed that Operation Richmond exists. I'm not sure, I think that might be the first time that you've publicly confirmed that the firefighters...
I think it is,
Yeah.
and I've done so because, as you pointed out, there's been so much talk in the public domain about it. I see little point in continuing to repeat the mantra that IBAC doesn't comment on legal or operational matters, but I can say nothing more than that.
No, well, but given that we've looked at 4 things now
Yes.
that are underway, and you've told us there's 31 others,
Yes.
in the public's mind, they don't appreciate the difference between, for instance, a politician, particularly the Premier,
Yes.
being called as a witness compared to whether or not someone is a suspect in an investigation. Is there some benefit in clarifying in what context someone is brought before you?
Certainly. So people that are called to give evidence may range from a person of interest, that is, a person whose conduct is under investigation and analysis, to a person who is associated with them, but it's clear that they've themselves done nothing wrong, but they have pertinent evidence to give that relates to the conduct of the person of interest.
Yep.
And you may have a succession of witnesses, all of whom are further and further removed from the immediate conduct of the person of interest, all of whom have got relevant evidence to give. Now, in a Royal Commission setting, where the government has identified a subject that it wants the Royal Commission to look at, all of those witnesses are called in public, and they're with the exception of a witness welfare issue, all of that evidence is public from the outset.
Yeah.
That's not the way the IBAC Act permits us to operate.
Would you prefer if it did?
In certain circumstances, yes, not in an unlimited way, but I think our discussions leading to the question, we should be able to have more public hearings than we do.
Which leads to that whole exceptional circumstances threshold, which was relied upon by the Federal Attorney General, Mark Dreyfus, KC, I nearly said QC, who insisted on maintaining it in the National Anti-Corruption Commission
Yes.
Act that's just passed the Federal Parliament, and a position that's being established. First of all, totally speculatively, are you interested in or applying for the position of the National Anti-Corruption Commissioner?
No.
You're not interested and you're not applying?
No.
Were you approached?
No.
That exceptional circumstances threshold, the federal government have said, no, that's what we're going to stick on. What you're suggesting is that it's not the ideal standard for them to have adopted.
It's not.
Because?
It's not. So I gave evidence at length to the Senate Select Committee, and they generously said in their report, at the end of their inquiry, that on the question of exceptional circumstances, they recognised that thoughtful and reasonable minds would differ about whether or not that exceptional circumstance should be applied. Having said that, I note that the entire Labor and Coalition membership of the committee spoke with one voice, without exception, that exceptional circumstances should be there.
To stop public inquiries except in the most
exceptional circumstances, whereas the
Everybody
Greens
else.
and the Independents all said no, it shouldn't. And one couldn't help but, of course, have an uneasy feeling that the reason that Labor and the Coalition took the position that they did was because they assume that one or other of them is likely to be in government at any moment of time, and it will be the members of Parliament from those parties that would then be exposed to public hearings.
From the government's point of view, I understand, and I think the Attorney-General has spoken about this, that it was more important to get something through that everybody supported than for the whole model either to disintegrate or become politicised over an argument about one clause and one aspect of its work.
Yes.
In particular, if once established, the new National Anti-Corruption Commission is going to turn its attention to the previous coalition government, you don't want to politicise the work of a National Anti-Corruption Commission from day one, do you?
Well, that may be a fair argument, John. I can't speak as to the politics and the numbers that influenced the Attorney-General to go down the track that he did. All I am saying is that thoughtful, reasonable people could differ about whether or not it's appropriate to have an exceptional circumstance requirement. My experience is, for the reasons we've already touched on, that increased privacy and confidentiality simply engenders a great deal of suspicion and distrust where, if it was in a public forum, that would all be dispelled.
On the one hand, you think it might be a good idea to make it completely secret that anything's even been referred to IBAC. On the other hand, you want more public hearings.
Well, I don't think the fact that a complaint is made to IBAC should be public. But once the complaint is assessed and it's the jurisdiction enlivened, I think there should be greater scope for the Commission to be able to go into public hearings. Bear in mind that we always have a requirement for each individual witness before we go into a public hearing that we have to be satisfied that there's no likelihood of unreasonable damage being done to their reputation. And if we conclude that there is, that puts out of question a public hearing.
Grab some water.
Thank you.
We need to make sure that you're well lubricated, even before the Christmas parties that come along. Speaking of damage, it's of tragic public knowledge that someone caught up in the Woodman inquiry, the Sandon inquiry, after being questioned and finding themselves a person of, I'm not sure what level of interest in that inquiry, took her own life. And we express, of course, great
Tragic,
and we express our best wishes to all her friends, families and colleagues. But at the same time, you were undertaking a piece of work. How do you take steps to make sure that doesn't happen in future? And secondly, what effect did it have on you and the team to find that your work impacted on someone in such a profound way?
Well, let me start with the effect. It had an enormous effect on the staff in IBAC. Everyone was distressed, and as you would expect, there were questions asked about whether or not, in any sense, we had contributed to that tragic outcome. And even if the conclusion were reached as we did, that there was nothing that we had done which we thought could have contributed to that situation. There's inevitably grave concern about the fact that outcome occurred.
You were investigating yourselves, which you criticise others, including the police, for doing.
So the ex-mayor had given evidence in public. She gave her evidence stoically. She made acknowledgements about wrongdoing in relation to a number of matters and commented that her conduct didn't truly reflect her values. She gave no indication that she was more affected by the public process than any witness who is inevitably distressed by the fact of having to give evidence, whether in public or private. It's a distressing and challenging environment. But this occurred long after she had concluded her evidence. It occurred at a point of time when we were in the natural justice process, and my understanding is that the draft or preliminary views had been given to her lawyers, but she hadn't even yet seen them. Her concern, I suspect, was that she was wondering whether or not she might be the subject of a charge. And let me say clearly for the record, that was never a prospect. So if there was a failing here, which we've obviously given serious consideration to, it is whether or not we can advance the point of time at which we can say to individuals, notwithstanding that there may have been some misconduct on your part, you should not have any fear that you are going to be prosecuted.
Subject to whatever else comes up in later inquiries
Correct.
from other witnesses. But from what we've heard so far, you might have been unethical, but you've probably not committed a crime. Is that what you're saying?
Correct.
And you don't say that now?
No, and of course that's part of the challenge of the natural justice process. Until it's completed, you never quite know what the state of the evidence is going to be. Somebody might come forward in their natural justice response and make some revelations that were previously unknown.
So in a way, it's a bit of chicken and egg when you're going through that process, but you're animated by that experience to think that that would be worth doing in future.
Certainly.
In other
And we
words,
are doing it.
the harm prevented outweighs the risks attached.
Indeed. One of the salutary outcomes is wherever we can, we say as early as we possibly can to those individuals who may have engaged in misconduct, but who might be uncertain as to whether or not it would be viewed as criminal, that we let them know that we're not their conduct is not under contemplation for the purpose of a prosecution.
And given you've told us that there's 31 other matters that are under investigation and at various stages,
Yes.
There are probably people there who you've already had in this room, which I might say is a fairly intimidating experience.
Yes.
And they've got the threat of IBAC still hanging over their heads. I mean, some of those people, well, you just don't know whether you can either confirm or relieve their distress.
In most cases, if there is distress about a fear of prosecution, that can be relieved. The circumstances in which IBAC recommends prosecution are rare. Most of those investigations you've mentioned are not investigations concerning what I would call black corruption, that is, which meets the definition of a relevant offence. We're talking about soft corruption.
One of the other issues that's been a political hot potato recently has been your relationship with the committee of the Parliament that's providing oversight. And
Yes.
there were allegations of interference. Now, I could go through them in some detail and recite them, but it's probably unnecessary for the hundreds of thousands of people who are watching us today who are well versed in every twist and turn. So let's assume people have some
Yes.
basic knowledge of what went on. Do you think that there was an attempt to nobble your reporting of your work?
I wouldn't put it that way. We are plainly dissatisfied with the way in which the parliamentary committee operated, particularly in the last 12 months. And it's our intention to place before both the Assembly and the Council, as soon as Parliament resumes, some documentation dealing with the way in which the parliamentary committee operated, with the hope that Parliament will give some urgent consideration to the composition and the constitution of the committee for future purposes, bearing in mind that that committee is the only institution to which IBAC can go for any remedy in relation to oversight of integrity issues.
What do you want changed?
Primarily the composition of the committee,
The individual makeup of it.
so that it no longer has a majority of members who are members of the party in government, and that the chair of the committee is not from the party in government. So that decisions made by the committee cannot carry with them the perception that that the decision was made for a partisan reason.
You won't comment on politics, and I'm not going to try and tempt you to, but given the outcome of the election that we've just had, given the overwhelming mandate that the Andrews government has had being re-elected, not just for a third term, but with quite likely, if not almost certainly, an increased majority from a previous what was regarded as a high watermark, hard to see that the government is going to empower other politicians other than their own when there are, first of all, so few of them, and secondly, such an endorsement from the voters of the way they've been conducting stuff in their previous 2 terms.
Well, that's politics, isn't it?
You think
I'm not sure that it's got anything to do with the level of success at the election. You would immediately recognise the likelihood that any government is not disposed to creating a parliamentary committee which might be composed of a majority that are not necessarily aligned with the government's views.
But given the parlor state of the opposition, and I don't expect you to comment on that, that'll be my comment, given the parlor state of the opposition, Victoria doesn't want to slip even further down the line of being basically a monoculture. The argument you put that some of the safeguards that need to be strengthened, I would have thought, is supported by the outcome of the election. In other words, the outcome of the election shouldn't be a temptation to increase the centralisation of power. It should be a reason to disperse it.
I agree. That takes me to the reason why it's important that I speak out, because the experiences which I've learned of as a result of the investigations of IBAC, the experiences of my fellow commissioners interstate, during which when we meet we share our experiences, the reviews that have been conducted interstate, the federal environment tells me that around Australia at a national level, the way in which decision-making now occurs within executive government gives rise to much greater latitude for soft corruption. And it is very disturbing from my perspective.
Encouragingly, you've done some joint investigations with the Office of the Victorian Ombudsman, Deborah Glass. She has an inquiry underway at the moment into the politicisation of the public service. Do you think that's an example of grey corruption, but not to the extent that IBAC gets involved?
It is an example, and it's a very important inquiry that she's undertaken. So my concern is that, as you mentioned, the centralisation of power, the growth in the influence of ministerial advisors, the diminution in the level of responsibility of individual ministers, and...
You mean the centralisation into the office of the Premier?
Correct.
Yeah. That's been going on for a long time.
It has 40 years. I can go back 40 years to see the first signs of it. But the point is that it's an evolution which has continued unarrested. And so it becomes increasingly troublesome with each decade. And we have
really corruption. Is it corruption?
Well, of course it leads to corruption. I don't mean corruption necessarily in the IBAC definition sense, but in the sense that standards, conventions, ethical conduct, the processes which contain within them the checks and balances that are designed to ensure that the outcomes of the decision best serve the public interest, they all get eroded.
That's not something... Well, it's not something that's happened overnight. We've already remarked upon. It's not something that's unique to Victoria. It's happening around Australia and around the democratic world.
Yeah.
You're almost asking the people who are the beneficiaries of that, the government, to correct themselves, which is unlikely to happen.
Not without pressure from the public, not without an understanding by the public of the sort of things that are happening which demonstrate that there is soft corruption, an erosion of the standards. And that's why the publishing of reports is so important. The Goldrake Review in Queensland, which should be graphic readings for any politician, is ample demonstration of the fact that, as in Victoria and elsewhere, we have a continuing erosion of the standards that are required. We do not have a public service that complies with the obligation of giving frank, fearless, independent advice.
And we've seen that with the Robodebt inquiry underway at
Indeed.
the moment, even more starkly.
Indeed.
A much overlooked part of the work you do is the oversight of police. And speaking of Queensland, they've just handed down an extraordinary report that says that after decades of people in that jurisdiction, and in fact all around Australia, all around many Westminster system countries around the world, police investigating police in Queensland, they've finally concluded just simply can't be sustained. Do you think
Yes.
it's a model that should be revisited and reviewed in Victoria too?
It's been said many times, not just during my period as Commissioner, that you need to have an independent agency that investigates all complaints about police.
All complaints. 'Cause
All complaints.
You oversee the system and you see what percentage of complaints?
2%?
2.
When you say oversee, we investigate 2%
Yep.
or 3%, depending on the year. We try and review another 8 or 10%, that is, those that go back to Victoria Police for investigation. We try and review as up to 8 or 10% of those to see that the right outcomes have been achieved, that the investigative process has been appropriate. But it's a very small portion.
You'd need
And
enormously much more resources,
course,
staff and all the rest
of course.
if you were to do
And the
anything else.
solution is not, as some people say, to create another organisation that would merely be moving the chairs around on the Titanic. Government, there can be no expectation that government's prepared to put aside hundreds of millions of dollars to give an organisation 1,000 or 1,500 more investigators to investigate police complaints. The solution lies in part in firstly having a realistic jurisdiction in relation to police. At the moment, our jurisdiction is enlivened by any conduct which might bring the police force into disrepute. You can readily see what sort of conduct that would include. There needs to be a mandate in relation to serious police misconduct, and if the government is serious about wanting all serious police misconduct to be investigated by IBAC, it will need to give IBAC considerably more resources than it presently has. I'm concerned that there's a myth that's perpetuated, particularly to the disenfranchised, the more vulnerable sections of the community, that if they make a complaint, IBAC will investigate it. We simply can't. We don't have the resources.
Even if you did, though, most of them, significant proportion of complaints about police are not the sorts of things that an anti-corruption body should get involved
Correct.
in anyway.
Correct.
They're service standards.
Correct.
Someone was rude to me or someone misled me or they wouldn't investigate something I thought should be investigated. My car got stolen. They
Yes.
didn't seem to care. That sort of complaint.
Indeed.
You don't want to get involved in that stuff,
No.
do you?
No.
But the more serious stuff, someone stole from me or my case was interfered with by someone's mate or whatever it might be, that's corruption. And that's not being looked at properly at the moment either, as my understanding.
No. I do have a concern that I know in the new year it's expected to be legislation which will seek to give IBAC a greater role in investigating police complaints by removing the existing requirement in the IBAC Act that we give priority to serious public sector corruption. I think I'm disturbed by the notion that our role in investigating serious public sector corruption should be diminished for the purpose of giving a greater role to investigating police matters. The solution doesn't lie in a redistribution of the existing resources
Within your current framework.
Correct. It should lie in additional resources.
Money. How much more money do you need? Have you put a pitch to Treasury?
No, we have not.
Has someone done a costing?
Because to put a pitch, we need to understand what the government policy objective is.
But those resources would be shifted from the police department, which is currently doing that work, over to IBAC. It would involve transferring a chunk of money. It's not new money, it's money moving from there to there.
Well, if one could identify and isolate what portion of expenditure at Victoria Police level is being utilised for that purpose, I'm not sure that that's ever been done. You have a task force of about 200 in the public, in the professional standards group. They look at perhaps 10% of what we refer back. The rest of that goes out to the regions. The be a very difficult exercise to quantify. No doubt it can be, and if that's done, and then government's willing to significantly increase IBAC's resources, then maybe we can say that we could investigate 15, 20, 25% of more serious complaints, but it's still only going to be a small proportion of them.
The Gobbo Royal Commission gave us an insight into the police culture of unaccountability, did it not?
Oh, indeed.
At the highest levels.
Yes.
Isn't that the problem? The internal culture that they're accountable to almost nobody.
It's a huge workforce, that there are cultures within the workforce. We do an enormous amount that doesn't see the light of day in terms of lectures and education programs with every level of Victoria Police, all of which is directed to ensuring the right cultures operate. But you know, we are dealing with the human condition. We're dealing with the truth about how people operate within any hierarchy, their obligations of allegiance, loyalty, mateship. These are problems that will always exist.
This is possibly your last public statement. What advice do you give to the next IBAC Commissioner, given that your term expires in a couple of weeks?
To be fearless. Because I do fear that because of the investigations, which have not yet seen the light of day, there will be pressure placed upon the organisation, and I think it's really important that the new Commissioner is fearless in continuing down the path that we've established.
Have you been fearless?
I hope so.
Have people tried to stop you? Has anyone ever sort of sidled up to you in the sandwich shop at lunchtime and said, better off to leave this one alone?
No. No.
It comes in more subtle forms than that, doesn't it?
Indeed.
Has anyone ever said, you know, if you didn't go so hard on this, we could probably find you a couple of extra mil for your budget?
No one said that either. But that's one of the reasons why we're concerned about the Parliamentary Committee, because we've not had the support from them that I think was warranted.
What's your legacy?
I hope that there's a recognition there's much more to do in the soft corruption area, that hopefully with cooperation, government also recognises that the decision-making processes that are presently utilised and which don't necessarily follow the right processes and comply with all of the checks and balances is a slippery slope that leads to the higher risk that outcomes don't serve the public interest.
What does Robert Redlich think of corruption in Victoria at the end of his term that's different to what you thought at the start of your term? You'd worked as a barrister, you'd been a judge, you'd seen the legal system from its grubbiest and all sorts of cases we don't need to go into. How did your views change during your time here?
Well, I need to say immediately, I had hardly any exposure to the public service as a judge, other than in the sense that some public servants support the court. My exposure to the way the public service and government operates really started with the commencement of my period as Commissioner, and I can't say that in that period of time that there's been any noticeable change in the way in which things operate. I wish things could happen that quickly, but in the end, nothing will change until there's enough information out in the public domain that creates a demand on government to be seen to be making change.
So it's about the perception as well as the reality.
Correct.
Which requires, we're going full circle here, does that require whoever takes on the task next, whoever the government appoints and gifts this crucial office to, does it require them to be more outspoken, to be more outward facing than you have? Because you've become outward facing at the end. You started off being allergic to it.
Yes, that's true. Yes, I would hope that one of the lessons to take away is that selectively there is more said in the public domain that advances the interests of Victoria being a state of high integrity.
And going back, are there things you now know that you had no inkling of when you started that have left you going, whoa, I never knew that?
Many things.
most significantly?
Many things. The way executive government operates.
Is it worse than you thought?
Indeed.
Nastier?
Not nastier. I just think that there's certainly ruthless, but simply that there is not enough attention given, as I indicated, often I think because there's little insight into the extent to which procedures, conventions are departed from. There's not much consideration given to those departures because it's simply the order of the day.
Were you perhaps naive not to realise how rugged people can be at that highest level of exercising power?
Perhaps.
Until you see it up close, and certainly in the work I used to do, you see it up close and you go, whoa, okay. That's how it happens.
And that's why discussion in the public domain is so critical, because it's through that discussion and through people in power reconsidering the way in which they go about discharging their functions that one can hope for change.
So you finish up at the end of the year. Do you become one of those ex-judges, ex-anti-corruption commissioners who joins the Integrity Roundtable or Transparency International or takes up a fellowship at a university so you can continue to speak out?
Perhaps. I have no plans. I noticed at least one of the retiring ministers from the present government said recently it shouldn't be up to those retired judges and those sorts of institutions to be telling government what to do. It's for the public at the election box to let us know when they disagree. The flaw in that reasoning is the public has to know about the errors that are occurring if they are going to be able to vote with knowledge and information about the situation that exists.
And we're going around again, it's the slippery slope argument, isn't it? And you see what's happened in other jurisdictions. You see what's happened in particular in the United States during the Trump era, and you go, okay, well, this is where, before you know it, you can end up there. Is that your worry?
I see us being some distance away from a Trumpian outcome, but we are on a slippery slope. Our standards have declined, and that has to be arrested.
Well, we've seen conspiracy theorists and coup plotters arrested just in the last 24 hours in Germany, for instance.
Yes.
It's not unimaginable. And surely we have to acknowledge the work that your organisation does and others. That's one of the essential safeguards.
Indeed, it is.
Well, it's an important role to play. Robert, it's been Commissioner, I was told to call you. It's been absolutely wonderful to be able to pick your brains. You've been generous and full and frank in answering my impertinent questions, for which I'm sure the audience are very grateful, and we thank you. Best wishes to you for whatever it is that post-IBAC life delivers.
It's been a pleasure talking with you, John.
Well, I think we're all the better for understanding some of what's been swirling around. Haven't gone quite as far as perhaps you wanted to, but we've gone as far as your own legislation permits you. So thank you. On International Anti-Corruption Day, I think we can say a very big thank you to Robert Redlich, AMKC IBAC Commissioner, as he completes his term as Victoria's Anti-Corruption Commissioner. Thank you very much for watching and for listening. I hope you've enjoyed the conversation. Goodbye.